Okay, welcome everybody. Welcome and thank you for joining Senior Concerns Seminar Series. I'm Martha Shapiro. I'm the Director of Programs at Senior Concerns, and I'm very excited to present this topic to you today. For those of you that aren't familiar with Senior Concerns, I just want to let you know about some of our core programs and services. We run a Caregiver Resource Center for the East County. So we offer caregiver support groups, and we have a full-time social worker available to talk with you about your situation and offer resources and assistance. We also have our senior advocates. You can give us a call and speak with a senior advocate about any issues or questions you might have regarding housing, benefits, Social Security, Medicare, you name it, we're here for you. We provide the Meals on Wheels program for Thousand Oaks and Newbury Park. And recently, we have started a volunteer grocery shopping service as well as an emergency food pantry to serve our community so that our older adults can stay safe at home. We have some new programs that we will be starting very shortly. One is called Think Fit. This is an evidence-informed fitness program for your mind and memory. This will be held over Zoom. It'll be a twice-a-week program that you participate in to really strengthen all areas of functioning for your brain health. You can learn more about it on our website. And we also plan to start shortly a new in-home comprehensive geriatric assessment program to support you and your family at home with resources, information, and a personalized care plan. So you can always call us at Senior Concerns or go to seniorconcerns.org to learn more about these programs. Now, our presentation today will be recorded, so if you want to view it again or share with friends and family, it will be posted on the Senior Concerns website. You just go to seniorconcerns.org/seminars, and you can learn about all of our upcoming seminars, click to register, and also view all of our past recorded seminars. So that will be available to all of you. We are viewing this today in webinar mode, so that means that you are in listen only. So if there's any issues that come up, if you kind of move your cursor on the screen at the bottom, you'll see something called chat. If you have a question for me or a technical issue, you can type it in there and I will get it. If you have a question for our speaker today, you'll see another box called Q&A. Please type your question in there. Our speaker today is happy to respond to questions as we go through the seminar so that you get your answer as it pertains to what he's speaking about. So please feel free to type questions as he is speaking and we will respond to them as soon as we can. So now I'm really excited to introduce our topic today. The title is The Legalities of Hiring In-Home Care During COVID-19. And this is a really important topic for all of you that are hiring home care workers so that you can be prepared and safeguard for your family. So our speaker today is Jonathan Frazier-Light, Managing Attorney with the firm Light Gaber. Jonathan Frazier-Light has more than 30 years of experience in the field of employment law, is AV rated by Martindale-Hubbard, and has been named multiple times as one of Southern California's super lawyers by Los Angeles Magazine. As the managing attorney at Light Gabler, Jonathan and his team members consult with over 1,500 companies throughout California regarding their day-to-day employment law needs. He has successful jury trial, court trial, appellate, labor commission, and binding arbitration results in lawsuits and administrative claims involving discrimination, harassment, class action, wage and hour, and other employment-related matters. Jonathan is a graduate of the UCLA School of Law, where he was a member of the Law Review. He is the author of 2 editions of the nationally acclaimed and award-winning book, The Cultural Encyclopedia of Baseball. And I feel like we might need another talk on that topic. Very interesting. He is screen sharing today to show you some of his information. I emailed a copy of this out to those that I had registrations for yesterday. But if anybody didn't get it, I'm happy to email it out to the rest of you tomorrow. So thank you, and I give it over to you, Mr. Light.
Hey, let's get started. So I'm going to scroll down a little bit here, and we'll get to the first topic. you'll have a personal caregiver who wants to come in and they'll try to negotiate with you to be an independent contractor because they don't want taxes taken out. They'd rather get the gross money. They'll take care of their taxes on the other end. You cannot do that. They are not independent contractors. They are employees. And even if they say, no, no, that's fine, we can do a written agreement that says I'm an independent contractor, the law says that a worker cannot waive their rights under the law as a matter of public policy. So no matter what they tell you, they cannot be an independent contractor when you hire them to care for your elderly family member or for yourself. So you do need to take out taxes. You do need to have a pay stub or some sort of a sheet that gives them all their details of what you've taken out. You can work with a bookkeeper or your family accountant, and they can set that up for you or direct you to someone that can do it cheaply. But you really have to keep them as an employee. And the pay stubs have to be accurate because there's a penalty for that. If you have an inaccurate or no pay stub, that's $100 per pay period, up to 40 different pay stubs. And then we'll talk about where this is all going in terms of dollars and value. But I will tell you up front that the damages can be horrendous. And I'm going to walk you through an example where you'll just be shocked. And then what kind of a pay period are you going to have? You are treated just like any other employer in California as far as pay periods. It's a week or bi-weekly every 2 weeks. It could be semi-monthly. Most caregivers like to be paid weekly or at least every 2 weeks. That's fine. But when it comes to things like overtime and calculating what they're owed, you have to do that on a weekly basis, even though you might pay them every 2 weeks or semi-monthly. And then depending on, and your bookkeeper can help you with this point, but depending on the pay period or the pay cycle, you have 7 days to pay. So if you close your 2 weeks or your week on a Sunday, you'd have until the following Sunday to pay them. If you paid twice a month, then you have 10 or 11 days, depending on which part of the month it is. But if you look under D2 there's special rules that it has to be a calendar month. So those are details you can work out with your bookkeeper or whoever's going to do the payroll for you. But you need to have a pay stub. You need to treat them as employees. And don't pay them cash. If for some reason you're going to pay cash, which I highly do not recommend, at least get a receipt for what you paid them and have them initial what you paid them for. Because as a stopgap, if they come back later and say, I didn't get paid overtime or you never paid me, you'll at least have some cash record of what you gave them. It's not a preferred method, but I have had a couple of situations, frankly, where someone was paying someone they knew was illegal and they paid them cash, but they had a record of it. And when they got sued later, we had a good defense for those payments, but not a recommended strategy. All right, let me move down to number 2. Your options of hiring them directly, or you can hire a home care agency. Now, the negative with that is that it's just more expensive. They're going to charge a premium for all the things they have to do. But if you can afford it, it's a much more fail-safe way to handle it because the burden's going to be on the home care agency to handle all the details, to pay properly, to do pay stubs, to screen the workers. Especially now with COVID, they may have a much more elaborate screening process. I'll talk about the COVID issues at the end. They're not actually on this outline, but we'll hit those at the end. But one of the keys with a home care agency is 2A. You've got to have one that's got a long history. I've had enough cases now where the family comes to me and says, we're being sued by our caregiver and we're trying to get the home care agency that we hired for this person involved, and they've disappeared. Or they can be pretty fly by night and do strange things, and the owners just close up shop, they reconstitute down the road somewhere else as some other company, and you're stuck. Because trying to find them and track them down and getting them to pay is a very difficult proposition. There are several reputable, long-standing agencies in the county. Find one of those and use them, and do not use small mom and pop that may not have the resources to do things correctly. I've had several of those smaller agencies I've dealt with that had no idea they were supposed to do things a certain way. The other thing is on 2B, make sure you're reading whatever the agreement is, because typically when you bring in a home care agency, there's a tendency to put the burden, or at least some of the burden, on you, and that's what you want to try to avoid. And so there may be indemnification provisions that say, well, you and your family control the work environment, so we as the home care agency are not going to be responsible. The better, more reputable agencies generally don't try to do that and push it on you, but there is an argument that under 2D there, that you are a joint, what's called a joint employer. And even though somebody else is supplying the labor, there are case law to suggest that you're both the employer and you can be tagged along with the home care agency. The other thing that comes up is 2C. Sometimes what you believe is a home care agency that's hiring your worker is actually a referral agency. And there's some very specific law that if they do it correctly, they are a referral agency and not the employer, and you become the employer of record. They are referring the worker to you. They suggest a format, they suggest pricing, they come up with a contract for your use, but because they've jumped through these specific hoops, they call themselves a referral agency, and it's legitimate, and you're stuck. So you may want to ask the question and get in writing, are you the hiring agency as a home care agency, or are you a referral service or a referral agency? There's a very big difference there because you want them to be a home care agency that's an employer and not a referral agency. Otherwise, you're going to be stuck with liability as a joint employer. All right, so here's where things get interesting. On number 3, most of you will hire someone to care for your family member who is what's called a personal attendant. And personal attendants are a special animal that I'll define in a minute. Whoever you hire into this position, whether it's a licensed, an LVN or a certified nurse assistant, CNA, or a nurse, or one of these personal attendants who's more of a companion, a caregiver, you are governed by something called Wage Order 15. And the California Industrial Welfare Commission has 17 of these wage orders. Every business, every employer is subject to them. So I'm in Wage Order 4 as a law office, manufacturing, Wage Order 1, hotels, restaurants, schools, Wage Order 5, and then domestic workers, which is not an industry order, but a position or employee order, is Wage Order 15, and that's who you would be hiring under. And there are special rules, and there's a link there to this particular wage order, and that's the place where every business, or in your case, the family engaging this person, is governed by certain rules. Overtime, meal breaks, days off, meal and rest break allowances. If there's lodging, there's credits for that. And I'll talk about that a little bit more, but this is the basic framework that you have to work under. And you may or may not have someone who's a personal attendant. And that's a defined term that we're going to talk about. So a personal attendant, I'm looking down at B on this screen, is someone who spends no more than 20% of their time cooking, cleaning, driving, not doing any medical procedures. They might help someone take their medicine. It might help track their simple things like take a temperature or blood pressure, but no medical procedures whatsoever. And if they spend less than 20% of their time doing that, they would be doing things like helping in the bathroom, helping to dress, helping to bathe, light cooking, very light cleaning or laundry, but something that doesn't take more than 20% of their time. And if you keep them below 20%, they are then what's called a personal attendant. And typically that's what you've hired. And the reason why that's important is because it has a direct effect on overtime issues that you have to pay or not. And it has a direct effect on meal and rest break rules that won't apply if they qualify as a personal attendant. And I work with some of the agencies that have personal attendants, and we have some forms set up and procedures set up so that the worker knows that they cannot spend more than 20% of their time doing those ancillary duties. Because if they do, now all kinds of bad things happen with respect to overtime and some other issues that we'll cover. So that's the general rule, and that wage order that I talked about in this subpart 2 that you can see on the screen at the top of this section, the personal attendant is subject to that wage order, but not to things related to meal and rest breaks, and not to things related to overtime, which would be section 3. That's not one of the ones they'd be covered by, and that's a very important distinction. And then tracking the 20%, you can, and I like to do an agreement with the caregiver that lays out what their duties are, and that they are not to spend more than 20% of their time doing those specific cleaning, cooking, laundry, that sort of thing, so that everybody's clear about what they can and can't do. And if they ever think they're going over the 20%, then they need to let you know so that you can adjust their workload, because that 20% thing is a big deal. And then, as I said, under C, no medical procedures. Now, all the regular overtime rules in California apply to people that work in your home. let's say you had a maid or a butler or a regular, you got a big estate and you've got a gardener who works for you relatively full time. Um, Anybody or someone who's caring for your children, anybody who works in the home is subject to all the regular overtime rules in California, except these personal attendants. And they have special overtime rules that's under D there. And we'll talk about that a little bit more later when we get down to number 9. But the bottom line is that most people know that a worker in California is subject to overtime if they work more than 8 hours in a day or 40 hours in a week. With a personal attendant, your person that you're probably going to hire, it's a different rule. The standard is 9 hours before overtime kicks in. And then a little bit of a wrinkle. The California law on this says 9 hours and 45 hours. Except that there's a federal law. In California, you have to follow both state and federal law. And the federal law on domestic workers, even for a family in your situation, is a 40-hour standard. So even though California has a 45-hour standard, you have to follow the federal 40-hour rule. And you always have to follow, regardless of what kind of employer, big, small, doesn't matter. You have to follow in California the law that most favors the employee. So in this case, you have to pay them after 9 hours of overtime and after 40 hours of overtime. And that's the standard that typically applies. And when you've got someone working 5 or 6 days a week, it's almost always going to be the 9-hour rule because you're always going to go over 40 hours or even 45 hours. So the other thing that's special about personal attendants, other than this 9-hour rule, is that you don't pay double time. And the typical rule in California is that an employee, a big or small employer, if they work more than 12 hours in a day, they get double time. That's not true for personal attendants. There is no double time. So that's another little benefit that you get. So far, having a personal attendant, that 20% rule, no overtime until they hit 9 hours, and no double time at all.
Can I ask you to clarify the definition of personal attendant and the 20 versus the 80%? Because I'm getting some more questions.
Yeah, the 20%, they cannot spend more than 20% of their time doing more than the caregiving, the personal care of the person. A companion, taking them on a walk, playing games with them, reading to them, helping them in the bathroom, helping them dress, helping them in the bedroom. All those things are what caregivers do, and you can spend as much time as you want on those basic caregiver activities. What you cannot do is let the caregiver go, like they come in and they spend 4 hours on one of the days cleaning the house, or they spend, they're cooking meals for the family, and they're doing 3 meals a day for the whole family and then cleaning up, and then they're cleaning the house, they're doing laundry that's not personal to the patient, and or they're driving on errands other than with the patient with them. Those are the kinds of things that get you in trouble with the 20%. Most caregivers, if you really break down their day, are spending the vast majority of their time. Like if you've got a 24-hour duty caregiver, 20% would be about 5 hours. And there's no way they're spending 5 hours cooking, cleaning, shopping, and doing those ancillary duties. So you're usually in pretty good shape with a 24-hour person. If it's a 12-hour or an 8-hour duty person, there's going to be a little bit of cooking and maybe some light cleaning, but typically you've got a house cleaner that comes in to do that work and not the caregiver. But if you do use the caregiver, you just have to be mindful of that. So that, I think, is about the best I can do on the 20%. There's information out there online that says what's a personal attendant, what's the definition. If you need more help, you can look there or let me know. All right, so let's keep moving here. Now, the other thing to keep in mind is that occasionally, oh wait, let me go back this way. Occasionally, family members will hire a caregiver to go treat their family member in a facility, a 6-bed board and care, which is a home that's been converted by license to board and care, or a SNF, which is a skilled nursing facility. They're recuperating from a stroke or some serious surgery, and they need some personal attention in the facility. The personal attendant rules do not apply to that facility or to someone working in that facility because it's a different wage order. It's not a domestic worker. Now they're working in a facility, that's wage order 5, different rules apply. So this only happens when they're working in your home. All right, now meals and rest breaks is also kind of a big deal here. And the reason is that all the meal and rest break rules that apply to a worker who's an hourly, non-exempt worker, which is what these personal attendants are. And we're going to talk about daily rates and salary and stuff like that in a minute, which you cannot do. They are hourly people. So because of the nature of their work in a home, you still have all the meal and rest break rules to observe. So if you had a maid, for example, they'd still have to take a meal before the end of their 5th hour. They'd get a second meal if they work more than 10 hours, and they get rest breaks under 4C there. 10-minute rest break, which is paid time, unlike a meal break, which is non-paid time. But I'm going to skip all that in detail because there's a very important distinction here. If they are a personal attendant, then the section of the wage order 15 that covers meals and rest breaks has an exemption for personal attendants. So you're supposed to get an off-duty 30-minute meal break. Doesn't apply. They're supposed to get a 10-minute paid rest break. Doesn't apply. The theory being that they can't really leave the premises, and so they've created a carve-out for personal attendants in that defined term that you don't have to worry about the meal and rest break issues. And the reason why it's important is because if they get screwed up, you owe them an hour of pay at their hourly rate for any day in which the meals are screwed up, and a second hour for if any of the rest breaks are screwed up. So if they are personal attendants, they're exempt from those rules. That's a big distinction. All right, let's move on. So workers' compensation, these are employees, you have to have workers' compensation. Now the good news is that the homeowner's policy or the renter's policy should have a workers' compensation component to it. It's a small percentage of the policy. I actually had someone years ago tell their broker that they didn't want that on there and they were not going to pay for it, and so they took it off, and then they got hit with a domestic worker claim and there was no work comp coverage, so that was a big mistake. But check with your insurance broker who writes your homeowner's policy. They should be able to confirm that there is a workers' comp component. Like if a babysitter got hurt on your premises, that would be covered by your homeowner's work comp piece. Same thing with the personal attendant. So just double check that you have it. If for some reason they think it's a good idea to buy a separate work comp policy for that worker, I would check into that. I'm not an expert on the insurance issues, but I do know that typical homeowners and renters policies have that component already built into it. So if that person gets hurt, your homeowner's policy should cover, but confirm that with your broker. Okay, so here's another point that you want to be careful about. You do not want to be writing checks on your account if it's your parent who's the hiring person. You may have power of attorney, you may have a conservatorship, you may have a trustee, trust situation, but you do not want to be writing the checks and be the employer. Now, there's an argument that you could be responsible for that person because you control what they do as the agent for your parent. But we try not to go there if we can, but it's very important that you don't walk into something and make it tougher to make those arguments by writing a check on your personal account or hiring the person as the son of your elderly parent and you're the engaging or contracting party. You don't want that. The contracting party is your parent or whoever the elderly person is, and they need to be the ones whose checking account you're writing all the payments to. So everything needs to be handled by the book, so to speak, so that you're not tagged as the employer and then they can get to your assets. Because mom or dad may not have a lot, and if there's a lawsuit later, one of our arguments is there just isn't that much money in the estate, so you're gonna have to take less than you really want. And so you don't want your money commingled in this situation. So just be wary of that.
Is there any sort of accommodation if the person receiving the care is your spouse?
In that situation, you're kind of stuck because you're the only way you're going to get around that. And I'm no expert on the family law issues, but I have had situations where an elderly couple actually gets a divorce so that one of them qualifies as, I think, indigent. I'm not sure if that's the right terminology, because their assets are diminished, and then you've protected some of your family assets because of our marital laws in California. But if it's your spouse, you're probably going to be stuck because it's a joint situation. All right. So now the shifts that you can use is pretty much whatever you want to do and whatever the caregiver wants and what you can negotiate, what the home care agency recommends. And it really depends on the level of care that you need. So if someone needs to be there 24 hours and they're a live-in, it's going to be a 24-hour shift. That's fine. Sometimes there's shorter shifts. If overtime is an issue, you can have shorter shifts. Keep in mind that you might have two 12-hour shifts. Somebody does the night shift, somebody does the day shift, and then you've only got 6 hours of overtime, 9 plus 3, as opposed to a 24-hour shift where you're going to have 9 hours of regular pay and 15 hours of overtime. It's a lot more money. And then also the days off requirement, that's true for the 24-hour workers, but again, if they're a personal attendant, the laws are a little bit different because the wage order doesn't, they're not subject to the wage order that requires 2 consecutive days off. They could actually work 6 days a week. You'd have to come up with some sort of a substitution on the day that they're off, and somebody else is going to have to cover, and they need to be able to be off for that 7th day. There is an agreement that occasionally they can work 7 days straight, but the law also requires that they're supposed to get 4 days off in 28. And it doesn't have to be exactly one every 7 days, but that's recommended, and the employee has to agree to work that 7th day. So there's a little bit of nuance with the 7th day issue, but in general, you're going to be giving that caregiver time off, and you'll have to arrange for a second caregiver to substitute in. Sometimes what will happen is you'll have 2 caregivers splitting the week. One does 4 days, 24 hours a day, the other does 3, and then the next week they switch. And the 7-day off thing starts over when there's a new work week. So if your work week is Monday through Sunday, and they started working on Wednesday, they can go till the following, they could work actually Wednesday through Sunday and then another 6 days. They could work 12 days in a row, and there's no penalty because it starts over again when the work week starts over. A lot of detail here that you don't necessarily have to retain at this point. All right, let's move on to number 8. So here's what happens. You have the ability under the law that if the employee is working for you and living in your home, you can credit some of the money you owe them against the value of the room that they're renting. So it's about $50. I have the number here. Let me pull it up. It's down below here. Yeah, it's not coming up. Yeah, there we go. So it's $56 a week for this year, and then it goes up a little bit next year. But it has to be in writing. And so if you're paying someone, and it's tough to get caregivers at minimum wage these days, they're probably going to be 15, probably more like $18 an hour. But if you're crediting against that number, let's say you're paying them $4,000 a month in hourly wages, you can reduce that by a couple of $100 based on that lodging credit. Same thing with meals. I didn't put the numbers in here, but it's about $17 a day. If they're eating your food, you can credit, there's a separate value for breakfast, lunch, and dinner. It's about $17 a day this year, and that goes up next year also. But that's if they're eating your food in the home. But these credits, which can be useful, there's some value to them. You've got to make sure that that's in writing and it's specifically understood that this is being credited against the minimum wage obligations. Otherwise, it's entirely void. Also, if you require the employee to live on the premises, there's a certain cap. So even if you're not charging against minimum wage, but you are requiring them to live there, which is not unusual, then you can't go above that $56 a week for the room. If you don't require them to live there and they want to because they need housing, then you can go higher, but we have to do a little bit differently. You can't make it a credit against minimum wage. Again, some more details that we don't need to get into right now. All right, I talked about meals already. Okay, so the other piece of the law that relates to domestic workers is these personal attendants, is this Domestic Worker Bill of Rights that went into effect. I think it's been about 6 or 7 years now. And it dovetails with that wage order 15 that I was talking about. And before then, a personal attendant not only was not subject to meal and rest breaks, but they didn't get overtime either. So this law established their right to get overtime because, as I told you earlier, the wage order excludes overtime for personal attendants. So to fill that void, they voted on this law a few years ago. They implemented this law a few years ago. And it basically now says that workers get overtime after the 9th hour, but no overtime. So that's where that, or no double time. So that's where that comes from, this Domestic Worker Bill of Rights. Now, the other thing you have to be aware of is the minimum wage obligations. So for example, Ventura County doesn't have any cities that have their own minimum wage, but the city of Los Angeles, the county of Los Angeles, and its unincorporated areas all have a higher minimum wage, which is now 15 bucks an hour. It may be 14 for smaller employers. I'd have to check that. But the state minimum wage is what you have to be aware of if you're in Ventura County. And if you look at B3, it's different if you're a smaller employer, which is a home in a family situation. That's almost certainly going to be the case. You might have one employee, which would be this caregiver. So if you've got 26 or more, the rate's 13 bucks an hour. It's 12 if you're smaller. Now, that goes up each of the next 2 years. We've gradually been going up for the last 5 or 6 years. It's going to top out at 15 bucks an hour in 2022 for larger employers. I think smaller employers may have one more year after that, but I'd have to look. But the bottom line is, at this point, to get a caregiver at 12 or 13 bucks an hour is going to be very difficult these days. All right, so that's the minimum wage that you have to be aware of. And then we talked about 9C already. If they qualify as that personal attendant under that 20% rule, then you pay them their regular wage, their regular hourly rate. Let's say it's 12 bucks an hour for the first 9 hours. And then it would be 8 hours if you've got someone who's a CNA or LVN or a nurse. And then overtime after 8 hours for them, or 9 hours for the personal attendant. And then 9E, if they are not a personal attendant, they're entitled to double time if they're staying those long shifts. Now, typically, if you've got someone who's in the nursing category, they don't do 24-hour shifts. It's just too expensive. Plus, you're paying probably 25, 30, 35 bucks an hour. So they would typically do a shorter shift so you don't run into that massive overtime. Now, 9F is where you get in trouble. You are required to pay sleep time even if they don't need to be on alert, if the family member is pretty much self-sustaining. But if they are required to stay on the premises at night, you have to pay for sleep time. So that raises several issues. If we do a written agreement, you may have in there that because we have a spouse living there, I'll give you an example. I had a client who had, the wife was the one who needed the care. I think she had Alzheimer's. And they were in their mid-80s, and the husband was fully functioning, but he wasn't able to lift her, and he wasn't going to be someone who can handle things on a regular basis all day long. But because money was an issue, we told the caregiver in writing that you're not required to be here at night. Now, the reality is because they were living there, they were going to be there at night. And if there was an emergency, they'd pitch in and we'd pay them for it. But by saying that you are not required to be there at night and the husband would handle an emergency, even though probably the caregiver would still help, it allowed us to carve out 8 to 12 hours at night for sleep time where they were not on duty. And that can make a huge difference when you think about the cost of these workers. And I'm going to go through an example in a minute that shows you what the cost is. So that's a way to do it. Or you've got someone from the family that comes in and spends the night every night, and you rotate kids or whatever you do. But if you don't have an alternative and they have to be there because the family member is disabled enough that they can't be left alone at all, then you have to pay for the nighttime. Even if you've got guards on where they can't get up, it's sometimes in a 6-bed facility, they'll be strapped in so they don't wander around. There may be a situation where they can't even go to the bathroom themselves, or even if they can, but they need help. That caregiver is going to have to be paid for the sleep time. And it all boils down to, very simply, if they're required to be there, you have to pay them. Okay, so that's 9F.
Can I just circle back to the personal attendant question again?
Sure.
So first of all, if you're using them more than 20% of their time to do household tasks like laundry, cleaning, cooking, what are they classified as?
Well, then they're just a domestic worker, and then they're subject to that same 8 hours, and then overtime after 8, double time after 12 hours, just like every other regular employee in a manufacturing place or the various nursing categories. So they lose those exemptions, and they have meal and rest break entitlement. Now, there's some special rules with meals where you can have them sign an on-duty meal agreement, but there's no agreement for rest breaks. They'd have to be allowed to leave the premises for 10 minutes, or you'd have to pay them an extra hour of pay every day. If you're in that penalty situation, that does not get included in calculating overtime, but it is an extra hour or potentially 2 hours of pay every day if they don't qualify as personal attendant and they can't leave the premises. So there's a lot of extra problems if you don't keep them below 20%.
So one person is asking, if you hire a caregiver and for a 4-hour shift, probably that's the minimum required.
Okay.
And you just need them to shower and change the person's clothes, and that only takes an hour. Then what are you supposed to have them do for the other 3 hours?
Well, most of the time they're just a companion if they're supposed to keep an eye on them for 3 hours. But that's up to you as to what they do for the 4 hours. Now, keep in mind, if they're only doing a 4-hour shift or even a 5-hour shift, they're not entitled to a meal break. They are entitled to a rest break if they go over 3.5 hours. I mean, again, if they don't qualify as a personal attendant. But remember, everything you just described is personal attendant work. So none of this meal and rest break stuff applies even if they work 12 hours. But in a 4-hour shift, it's really up to the family as to what they want the person to do. If they're cooking and cleaning and there is a vacuuming and cleaning the house for 3 hours, then they are no longer a personal attendant. But in a short shift like that, the only issue that would come up would be a rest break. And can they take 10 minutes and go out and sit on the curb and do nothing? If that's okay, and the person can be left alone, then you're home free. It's not an issue. If you really want to be, if you're worried about that, don't let the shift go past 3.5 hours. Because once it goes over 3.5, now they have to get a rest break. But there's other rules related to 5 hours, they don't get a meal. 6 hours or less, they can waive it. But again, that only applies to non-personal attendants. Okay?
Thank you.
All right, anything else? All right.
Not yet.
Moving on. All right, now this is where it gets ugly. There's a big tendency for families, I'm looking at G, the daily rate versus a salary versus hourly. It's very common for families to say, we'll pay you $200 a day, $250 a day, $300 a day for whatever you do. And they don't really track the time because they're living there and they don't track sleep time and they're getting paid $300 a day, which is a pretty fair rate. You can't do that. You can't pay them a salary. Even if the employee insists, just pay me a daily rate, pay me a salary, $4,000 a month. You can't do that. And the reason is that if they work overtime, the law says that you've paid them zero for the overtime. If you pay them for a daily rate, and I'm going to show you the numbers in a minute, you've paid them zero for everything after 9 hours, again, assuming personal attendant. If you pay them a salary, you've paid them zero for everything over 9 hours. So that's where it gets really ugly in the damage claims when these things come up, because you've paid nothing, even though you thought $300 a day was a fair number and they were happy to take it. Again, they can't waive their rights under the law, so they can sign an agreement that says, I agree to take $300 a day as a daily rate and come back and sue you when you fire them. I mean, candidly, what typically happens is that the family member passes away and they're no longer needed, and then they go to an attorney and they stick it to you. And there's a firm down in San Fernando Valley that's very good lawyers, nice lawyers. I mean, they're easy to work with, but all they do now is represent caregivers. That's all they do. And they're making a fortune. And I'll show you why in a minute. Okay, so you must pay hourly and you have to establish an hourly rate that's at least minimum wage for the hours they're going to work. And then you have to calculate overtime at that time and a half rate for the personal attendants. All right, now expenses, same thing. You can't just say the employees, you're building it into their hourly rate. Can't do that. You have to pay them separately. Now they have to give you some backup for that. If they're using their vehicle to go pick up prescriptions or take them shopping or taking them on a drive, a couple of things. You're entitled to get a copy of their declaration page for their car insurance. But keep in mind, and you should check with your broker on homeowners insurance, is that typically if a caregiver gets in an accident while doing something on your behalf, doing an errand or taking your family member for a drive or whatever, your insurance is going to be first in line to cover, not theirs. There's always a fight about that. But the law seems to suggest, and the plaintiff lawyers always argue, and I think correctly, that they're working on your behalf, that their personal insurance shouldn't kick in. So check with your broker about that issue and see if you've got coverage and how that would work. And if the broker tells you that your insurance would not be primary, I would take that with some skepticism, and I would still insist that you have some coverage for this if it comes up. And then if they're using their phone to clock in their time or to contact you about issues or they're using their computer or a tablet to enter notes about the patient, that all has to be reimbursed at a rate that's deemed reasonable between you and the employee. There's no set rate like the IRS mileage rate. And the IRS mileage rate is actually a maximum. You could pay them a little less, but I'm not sure it's worth quibbling over another 15 or 20 cents a mile. They're probably not going to be doing that much driving. But you can ask them to give you the mileage in writing, and then come up with a rate. You know, if they're working full time and they're the only ones at the home, somewhere between 10 and 50 bucks a month is probably a reasonable amount, depending on how much they use their phone on your behalf. I pay my attorneys 50 bucks a month, but they're on their phones a lot. The caregiver may be doing it minimally, so $10 a month might be reasonable. But you do have to come up with something if they're using their personal equipment, whatever it might be. All right, now sick time, again, because you are an employer in California, they're entitled to have sick time. And it gets a little bit tricky. If you're in the city of Los Angeles, the city has its own sick time rule, same as Santa Monica, some of the counties up north. Ventura County has no sick time rules either by county or by city. So you follow the California version. And the simplest way to do it is to put, and I should have been clear about this. Let me see if I put it down here. I don't think I did. Yeah, so a couple of nuances here. Let me go to 10B real quickly. The sick time information, how much they have available, has to be given to the employee each pay period. So the simple way to do it is to put it on the pay stub. It's not required to be there, but that's where everybody does it. And so whoever's doing your bookkeeping and handling your pay, just tell them how much the person has on the books that pay period. Now, the simple way to do it is to just load it, what we call front loading, where we'll put 24 hours on the books. And once you've used it up in a year, it's done. And then they get another 24 next year. If they've got 17 on the books by the end of the year, you give them 7 more to put them back at 24. If they leave you, you do not have to pay out sick time. You don't have to give them vacation. You don't have to accrue PTO or paid time off where you combine vacation and sick. None of that's required. If they want to take a vacation, you could pay them if it's somebody who's been there a while and you like them, or you just say, fine, you're off and no pay. That's okay. Now, the tricky part with caregivers and the shift is that it's 24 hours or 3 days, whichever is greater. So if you've got a 24-hour duty person who like a live-in, their day is 24 hours, then you'd have to put 72 hours on the books, not 24. Now, the reason I have that 48 there is that some employers will do an accrual that you can accrue up to 48 hours in a year, and you accrue as you go. In LA, it's a bigger number. You can accrue up to 72 hours. But that's too difficult, not necessary in a home care situation when they're working essentially full time. If you've got somebody only doing 4 hours a day, 4 days a week, for example, and that's only 16 hours, the other way to do it, which I didn't put here, is to give them 1 hour of pay on the books, sick time on the books, for every 30 hours they work. So depending on the frequency of their work, you may want to do the 1 in 30 if they're really part-time. You may want to do the front loading, which I think is recommended, but you're going to have to front load. If they work a 10-hour shift, their day is 10 hours, you'd have to put 30 hours on the books. So it's 24 hours or 3 days, whichever is greater, depending on their shift. All right, I'm going to move along. All right, other benefits. So I got ahead of myself. Got way ahead of myself here. Let me go back. All right, so other benefits. None are required. So no vacation, for example. 11B is a little bit tricky, something called paid family leave. So in a regular working situation with a company, an employee can say, I have a new baby, or I have a sick family member I need to take care of, and here's a doctor's note. I want to take time off for them. And you have to allow them the time off, and they get to keep their job, and they get 8 weeks of pay from the state, just like they would get SDI if they were hurt, unrelated to work. You don't have to pay them anything, and technically you don't have to hold their position. And in this situation, you'd probably be justified in saying, I can't hold the position. It creates an undue hardship. But it's a leave law that might be available. If somebody ever comes up and says, I need time off, that's something you may want to talk to somebody about as to what you're required to do. The good news is that the regular laws about pregnancy disability leave or discrimination and protected categories, you have to have 5 employees for that to apply. And that's typically not going to be the case for your family member. We talked about 11C, the sick time component. You do not have to do vacation and PTO. And then of course, 11D, we talked about workers' comp earlier. All right, so now let's get to why this is also important. So I've had clients say, well, I know they're illegal. We didn't do an I-9, which you're required to do, and get their 2 types of ID to fill out the I-9 form. But they're illegal, and now they're suing me for overtime, and they went to the Labor Commission, or they got a lawyer and filed a lawsuit. How can they sue me if they're an illegal immigrant? Well, California has a law that says that illegal immigrants are entitled to all the protections of the wage and hour laws, regardless of whether they're legal or not. Now, they may get deported, they may be in trouble for other reasons, but you still have to pay them all their wages that they are owed. There's no protection just because they're illegal. And then, all right, so the biggie is the overtime. And this is where that problem with paying them a day rate or a salary comes in play. Because as I said, if they sue you, you've paid them 0 overtime if you did it those 2 ways. And then there's interest on the money you owe. And then there's penalties if they're not a personal attendant and you've screwed that up, which is an hour of pay for everybody. And then waiting time penalties, if you didn't pay them the overtime, for example, whether you knew about it or not, ignorance is not a defense, they are entitled to get 30 days of pay at their hourly rate as an additional penalty. And then there's pay stub violations. I talked about that if you didn't give them a pay stub or didn't show the overtime or some of the other things that have to be on a pay stub, you owe them $100 up to $40, which is $4,000. All right, so now I'm going to walk you through an example of how ugly this can get. Okay, so let's say you've got a 20, and I just had this case. In fact, I got today from the client, she's just about to close escrow, or she's getting a hard money loan on her mother's house to pay off the claim that this caregiver asserted. And the problem is the caregiver loved the mom loved the caregiver, mom's not quite as lucid anymore. And then the caregiver left kind of on good terms. And the client said, I never thought she'd ever do this. And she was the nicest person and she loved us. That's all out the window. And you have to assume that everybody you hire is going to sue you later. And that's why you have to dot every I and cross every T, because these are gotchas. And as one of my clients said, not in this context, but in a construction class action case, I didn't know that not doing, and he had little nits and nat things that he did wrong. I didn't know that doing nothing wrong is not the same as doing everything right. And that's the kind of gotchas that you can get here. So G1, 24-hour worker, 5 days a week for 2 years. That's what this woman did. So they paid her a very fair rate. They paid her $300 a day. And that's a good number in the grand scheme of pay for these things. It used to be when minimum wage was $8 an hour, they'd be paid for $120 a day, and that's all they got. Well, now we're in the 300 range, but they paid her a daily rate. So here's what happened. She should have been paid hourly, at least at minimum wage. So what that would have been, had she done it correctly, would have been 9 hours at minimum wage of $12 is $108. I don't know why that's coming up. Okay. Then 15 hours because she was 24-hour duty at time and a half, which is $18, would have been $270. So that total would have been $378 a day versus the $300 she actually got paid. So it was a $78 a day difference. So over 5 days, well, there's the 378 I talked about. And over 5 days, it should have been $390 a week, and over 100 weeks, let's say 2 years at 50 weeks a year, 2 weeks off for vacation, round numbers, make it 100 weeks. So she should have been owed $39,000, which is a big chunk of dough. But that's not the way it works. And you say, well, geez, she was only a little bit short, and that adds up to $390. $39,000 is a whole lot of money. And then there's penalties and interest on top of that. That's actually what she was owed in overtime. But that's not how it works. This is how it works. And it's terrible. Okay, so now you paid her $300 for the first 9 hours, as the law says, and you've paid her $0 for overtime. So you now owe 15 hours of overtime, and here's how it's done. You take the 3 hours you actually paid her, you're now punished for paying her more. If you'd been paying her $200 an hour, it would be whatever 2/3 of that is, be $22 an hour. But because you were generous and paid her pretty close to what you should have, which is exactly what happened with my client, you divide by 9 hours and you get a $33 an hour overtime rate for the regular pay. And now you multiply that by time and a half, and it's $50 an hour. I rounded a little bit. So you now owe $50 an hour of overtime for 15 hours a day times 5 days a week. That's 75 hours a week times $15 times 100 weeks is $375,000 before penalties. Okay? So that's the punishment you get. And my client, in her case, her mom owed $450,000. Now, the mom didn't have much money at all. She had a condo worth about $900,000 that was paid for. And they're now they either were going to sell it, they couldn't get a reverse mortgage. They found a friend who's got money who's going to loan them we settled the case for $240,000. The plaintiff lawyer that I dealt with is this guy down in San Fernando Valley, good lawyers, reasonable. They're not trying to bankrupt anybody, but they said, look, we know mom, because they do a property search. They know mom has this house and they know that it's got plenty of equity. So go find a way and get us paid. And they didn't do it that nasty, but that's basically what happened. And so the daughter is now in the process of getting this loan, and they're going to pay they paid $40,000 already, and they have another $200,000 that was actually owed September 1st. They got delayed because of COVID, but they're going to shell out $240,000 because they were short by $78 a day. And so that 39,000 number I talked about earlier doesn't apply. And then the reason why we get from 375 to about 450 is there's a whole bunch of penalties that apply. It's a little less than that, plus interest. So that's the fear of God that I'm trying to instill in you to do this correctly, because that's the kind of numbers. And this is not pie in the sky nonsense. I'll give you another example. I had 3 workers who had done this before. They rotated the weeks, one did 2, one did 3, one did 2 over 4 years. And I got a call from a business lawyer who was handling this case, who said the family members, the demand from the same lawyer was $1.2 million for these caregivers. He said, can that possibly be accurate? And I went through the math with him and I said, well, actually they made a mistake. It's $1.4 million for 3 caregivers for 4 years. So that's why you got to do this correctly, because it could break you, or certainly that's a big hit on an estate. And if you've somehow stuck yourself into the mix as the employer, your assets could be at risk also. So that's the kind of stuff we're dealing with here. All right, so we've got just about 5 minutes. If Martha, there's any questions, or I'm going to just talk about some of the safety issues.
I have one question. If you are paying them hourly, can you include the expenses and consider it a fully loaded hourly rate?
No. That's a simple answer, and there's no explanation. No. Even if the employee agrees, can't do it under that same theory that they can't waive their rights. And you've just jacked up your hourly rate for overtime purposes, so don't do that. You wouldn't want to do that. Because if you're adding another $1 or $2 an hour for the expense component, by doing that, you've just increased your hourly rate for overtime. So don't do that. Any others?
Nope.
Okay. So I don't have any wild pearls of wisdom. So what all that suggests is that rather than risk all this, instead of paying a caregiver $18 an hour plus labor burden and maybe $22 an hour, if you pay a service $27 to $30 an hour, it may be worth the peace of mind knowing that the reputable service is taking all the risk and doing it as correctly as it's probably going to be done. So that's my pitch for some of my clients who actually do this and do it correctly, because there is just a whole lot of risk here that you could screw it up. Okay, and if your business lawyer is helping you with this, or your estate planner, I can tell you from experience that they don't really know these rules either. And I've been consulted by several of them over the years when they say, we're doing some estate planning and we need your help to help figure this out because we don't know what we're doing. And if they say they know what they're doing and they're not an employment lawyer, be careful, because they may not.
So somebody's asking,
go ahead. Yeah,
someone's asking where they can get a contract. Are there templates they can use?
There may be contracts online. I've drafted simple ones. They don't take very long. I mean, you're talking about an hour or 2 of work to draft an employment contract for one of these caregivers. I've got a couple that I've done that I kind of use as my template. They're not hard and they're not fancy. It's basically an offer letter that when they sign it, that's our deal. They're an at-will employee that can be terminated at any time with or without cause or notice. You want that in there. and then the basic parameters of what they're going to do and what they're not going to do in terms of, like medical procedures and keeping under the 20%. So there's some specific bells and whistles in there. There may be templates online, but just be careful because sometimes you'll get a template that was created not for California and things are different here. And this happens with handbooks sometimes where I'll get a handbook created from out of state that they try to apply in California and it just doesn't work. All right.
There's a question related to COVID.
Yeah, go ahead.
Basically saying that the agencies hire caregivers that work for many families and so are exposed more. But an individual can work just for us and not have the exposures. It's not specifically a question, but can you kind of address that and any of the COVID issues we need to think about?
Well, that's obviously an issue. If you've got a wound care person or a physical therapist who's doing 1-hour visits for 6 people a day, it's a big risk, especially for the vulnerable population that we're dealing with. And I don't have any easy answers to that one. Yet you do minimize the risk, but keep in mind that that caregiver is still going home to family and may live with other adults or kids or teenagers or other people that may not be as socially distant and they may pick it up from somebody at home. So you're going to have risk whoever you use, and there's no magic bullet here that's going to help you. You can have them self-screen. You could do a temperature check every day, whether they have to, they could do something as simple as videotape themselves doing a temperature check and show the monitor so that they're healthy that day when they're coming to work. That's sort of a simplistic way to deal with it, but there are companies that are doing a screen as you walk in. They stick the gun on their head and it takes their temperature. So that's one thing. Having sanitizer at the house, the mask issue, if they're wearing their mask, they don't want to, I think most caregivers are pretty good about this in terms of, and when I say most, I would think, well over 90% are tuned into the issues because they're dealing with a vulnerable population and they don't want to get sick either. So they're probably going to be more careful than the average worker. Masks, sanitizer, washing their hands, and then temperature check if you're going to do it. You can do a wellness certification every day that they're well and healthy. If they lie about it, there's not much you can do about it. The other issue is if they do have COVID symptoms and they have to take time off, you, even as a tiny little employer, may be obligated and probably are obligated to pay them under the expanded FMLA leave law, where they can get up to 80 hours of pay from you for the 2 weeks that they have to stay off while they're in quarantine. Now, keep in mind that depending on the nature of the quarantine, did a doctor tell them to do it? Do they actually have the symptoms? Are they caring for someone with the symptoms? Then you do not have to, well, you take the hit, but you get an immediate tax credit on that payroll. Now, the problem is because you don't have any other employees, the tax credit's going to take a while to come back to you, because let's say you're paying them $1,000 that week, and the tax credit would only be $120. You're not going to have anything else to offset against the other $880. So it would take several pay periods for that to wash out. But that's something to talk about with whoever's doing your payroll, because most CPAs and payroll services and bookkeepers now have a code set up for COVID payments. But just because you're tiny doesn't mean that you have to do it. Although there is a hardship exception that you probably can invoke as a caregiver situation where you only have one family member. So I got a little ahead of myself there because there is that exception. And your situation is a fairly obvious one that you could say, we can't accommodate this because I got to have care for the parent and I can't let you take off. So you probably have an out to get around that. All right, I think that's all I've got.
There's one last question. I'm not sure this is an easy one or not, but how does this content relate to in-home support services providers?
Well, the IHSS has some special rules. I don't think they qualify as domestic. Well, they may qualify as domestic workers. We had a debate with that with someone who was in an IHSS kind of system, and I can't remember how we resolved it. If somebody wants to send me an email, I can check it, because we had a class action actually with those workers. And I think they qualified as domestic workers because they were working in the home. And so these personal attendant rules would apply, but I've got to check that because I can't remember. I think we made that argument. I think it was a good one, but I just don't remember. I know we settled the case and it ended up not being an issue, but I have had some experience with that. And I don't know if they were IHSS workers, but they were some sort of in-home support through the Tri-Counties Regional or whatever. I just don't remember. Or not Tri-Counties, it was up north. This one was in Oakland, I think. But I can certainly find out an answer. I just don't know.
Perfect. Well,
okay.
Thank you so much. This has been so much good information. It's a little overwhelming.
Totally overwhelming.
But I almost feel like just the fact that it's overwhelming kind of highlights to all of us just the need to really do our due diligence. And hopefully the handout will be useful because it will remind people of all the different categories and kind of that checklist of things that they need to be aware of to protect ourselves and our families. So it's really important information. So I really thank you for presenting with us today. And this, again, is recorded, so you are welcome to view it again if you need to review it again with Mr. Light. And our next upcoming seminars, we have 2 in October, one on the 13th, which is What's New for Medicare in 2021, always an important one that everybody should kind of do a checkup on. That's October 13th. And then October 27th is the very ever popular Will I Pass My Next Driver's Test that is presented by the California DMV Ombudsman. So that's always an important one. So those you can register for now on our website, seniorconcerns.org/seminars. Now people are just typing in thank you to you. I'm happy that you were able to provide this very important information. We really appreciate it. I thank you, and I thank all of our family members out there for doing everything you do every day and doing the best you can for your family. So if any other questions come up, please reach out and email me. And I hope you all have a wonderful evening. So thank you.
I'm going to go do 108 sun salutations in honor of the autumnal solstice and see if I can make it through that in my yoga class on Zoom.
That's amazing.
I may not make it. We'll see if my shoulders hold up.
Okay.
Yeah. All right. Good luck.
Good luck. Thank you all. Have a good night.
Bye-bye.
Bye.